Litigation finance in its origins lie in the distressed litigation space. Small, insolvent, or financially distressed businesses that had potentially valuable legal claims, but few assets with which to fund their own litigation, found financiers who were willing to provide non-recourse capital in exchange for a share of the return from a successful litigation. For steel-nerved investors in the early 200s, litigation finance was an exciting new industry that offered the possibility of awesome returns for investing in the right cases. Back then, there were relatively few financiers operating, and as such, they had their pick of financing opportunities and were usually able to negotiate incredibly favorable agreement terms on cases that they agreed to finance. Currently, the industry has become more mainstream. The practice in general has received judicial support in many common law jurisdictions, and now there are dozens of major financiers operating around the world. For financiers, the next big frontier has been to try and unlock the treasure of litigation financing within big business. This market segment is historically dominated by the hourly rate. With litigation finance, businesses would no longer need to carry as heavy of a legal team, because meritorious claims could be sent elsewhere, where it would not cost anything to pursue. Despite this potential benefit, corporations have been slow to embrace litigation finance. This may or may not be due to the tainted reputation of the industry, and that only distressed clients turn to such a solution. However, the tides have been turning. As the industry has grown and misconceptions have been realized as such, more big corporations have been utilizing its benefits. As time passes, look for more companies to utilize litigation finance as an invaluable tool to increase their profitability.